Hello, and welcome to Crime and Court. My name is Heather, and this is part 3 of the transcript reading for the hearing that was for the motion for contempt that Nick McLeland filed. He was trying to get Richard Allen, who is accused of the Delphi crimes. He was trying to get Richard Allen's attorneys in trouble, get them punished by Judge Gull for contempt. And so he filed this thing for contempt, and now we have the hearing for it. We're reading through the transcript. This is part 3. In part 1, we went through a bunch of motions, and we had Detective Stephen Mullen on the stand, and he's going to come back, and so is in the last episode, or the last part 2, we had Jerry Holman on the stand for the entire portion of the reading, because he was on there for a while, and he is with Unified Command, and there were lots of questions to be had and whatnot of him. It was very interesting. I recommend you go back and watch those first 2 if you haven't already seen them, so that you get caught up, because we are at part 3 here. I'm going to put the links to all the videos down below, plus all the Frank's videos that I've done, the Frank's memorandum, and the responses to those and whatnot. So check the description down below for more videos on this topic. All right, so direct examination of Detective Ben Rector. This is State Police. And before we get in, please hit that like button and let's dive in. All right, so Prosecutor McLeland is going to be questioning Detective Rector. Will you state your name, please? Ben Rector. And then he spells it. Move the mic over here. And how are you employed? A detective for the Indiana State Police. And how long have you been employed with the Indiana State Police? I graduated the Indiana Law Enforcement Academy on March 4th of 2001. And are you familiar with the case of State of Indiana versus Richard Allen? I am. I gotta hop to this other document here because it got split up. Again, thank you to Criminality, I think is how you say it. I don't know. They have, they went ahead and purchased the transcript from this hearing, and they made it in publicly available documents on a Google Drive. So thank you guys so much for sharing it with the rest of us so we can get this word out, because what's going on in Delphi is, it's a crime. What's going on in Delphi, all this corruption and cover-up. All right. Oh, sorry. I am not at the beginning here. Detective Rector, let's continue. Make it a little bit bigger here for you guys. All right. Again, continuing on, this is Nick McLeland asking questions and Detective Ben Rector answering. Question: and you became involved in the investigation into the leak of photos, is that correct? That's correct. Tell me how you became involved. I was asked somewhere around October 6th, I believe, give or take maybe, but I was asked to locate Brandon Woodhouse. Okay, and did you locate Brandon Woodhouse? I did. And did you have a conversation with him? I did. And what did you do after that? I had a conversation with Mr. Woodhouse, and then afterwards I was asked to complete an interview with Mr. Rosie and Mr. Baldwin. By who? Who asked you to? And did you conduct those interviews? I did. Those were completed on October 12th. And you were able to meet with Mr. Rosie and ask him questions about the leaked photos, is that correct? That's correct. Okay, and you were able to do the same with Mr. Baldwin? Yes, that's correct. When you interviewed Mr. Rosie, did he represent to you who the members of their investigative team are? He did. He gave me several individuals that were kind of involved on their team, yes. Were any of those individuals Mitch Westerman? No. Were any of those individuals Mr. Fortson? No. Did Mr. Rosie ever mention that Mr. Westerman was working with them as a consultant? He did not. Did he mention his name at all throughout the interview? I believe we discussed him, and I believe he said that I don't think he'd ever met Mr. Westerman to the best of my knowledge, or his knowledge. Okay, and did you discuss the discovery in the case with Mr. Rosie? We did. And do you know where they would usually keep the discovery for this case? Yeah, so we broke down the flow of discovery from your office through their hands, and ultimately, I believe Mr. Rosie's secretary would pick it up, and then it would ultimately go to Andy Baldwin's office. And did you ask him about the photos that were leaked to the public? I did, yes. Did he have any explanation of how those were leaked? The only knowledge he had was that Mr. Baldwin had told him relating to it. The only knowledge he had was what Mr. Baldwin had told him relating to it. Okay, and but what was that information? The only knowledge he had was that Mr. Baldwin had told him was what Mr. Baldwin. Well, what did Mr. Baldwin tell him? Okay, and see, they're not asking the appropriate questions. Okay, and did you then interview Mr. Baldwin? I did. And did Mr. Baldwin know Mr. Westerman? He did, yes. Tell me about that. So he was a former employee of Mr. Baldwin's office, and he had known him for several years. And did Mr. Baldwin explain to you how the leaked photos got out to the public? Yes. He outlined how he believed that had happened. And tell me his explanation. So Mr. Baldwin told me that on an afternoon of October 9th, I believe he received a text message from Mitch Westerman, indicated that he needed to speak with him. He stated that he had some plans that evening. However, he stayed at the office, and at some point in time, Mitch Westerman showed up at his office and informed him that he had taken pictures of these pictures. And did Mr. Baldwin mention that Mr. Westerman was on their team? He did not know. Did Mr. Baldwin mention that he used Mr. Westerman as a consultant? He did say that he discussed strategy related to Delphi with him related to the case. Well, doesn't that mean he discussed his strategy? I don't know. What do you guys think? Sorry, my lips are chapped and I keep messing with them. All right, so did Mr. Baldwin mention that he used Mr. Westerman as a consultant? He did say he discussed strategy related to Delphi with him. So doesn't that mean he's consulting with him about strategy and other things? I mean, do I have to spell it out for you and say I use this guy as a consultant? Or can I just say I talk strategy with my former employee? Still, you need to come out and say we only talk I don't know what they want them to come out and say. But anyways. All right, so question. Did Mr. Baldwin say that he released any documents to Mr. Westerman? He told me throughout the interview that I believe 1 to 2 days prior to the Franks motion being published with the court that he had provided that document to, or Mr. Westerman had shown up at his office and viewed the Franks motion 1 to 2 days prior to it being published, and I think that date was September 18th. Did Mr. Baldwin show you any kind of non-disclosure agreement that he had with Mr. Westerman? No, he did not. Did Mr. Baldwin show you any text or email or anything confirming that he had a non-disclosure agreement with Mr. Westerman? No. Did you discuss Mr. Woodhouse with Mr. Baldwin? We did, yes. And what did he tell you about Mr. Woodhouse? He informed me that he had inadvertently sent Mr. Woodhouse, I believe what it was called was a thumb drive map outlining some evidence or related to a hard drive that he was given. Did he explain to you why he had Mr. Woodhouse's email in the first place? Yes. He had consulted with Mr. Woodhouse, I believe somewhere around December of 2022, and discussing some things related to some knowledge that he may have of the Delphi case, or something intertwined with it potentially. So when you had a conversation with Mr. Baldwin, did he inform you that he'd also given the Franks memorandum to another civilian individual? He did, yes. And who was that, if you recall? I don't recall the name, but it was a CASA worker, I believe in Franklin County, but I don't recall the name. Did he show you any kind of non-disclosure agreement or any document confirming that she would keep the information confidential? No, sir. After your interviews with Mr. Baldwin and Mr. Rosie, what did you do next? Directly after that, I sought a search warrant to search Mitch Westerman's residence. And did you get a search warrant? We did. And was his residence searched? It was. And did you gather electronic devices from that residence? Yes, we did. Did you gather Mr. Westerman's cell phone? We did. And were you able to download the contents from the cell phone? We were not, no. Are you attempting to now? Yes, I believe so. Tell me about that. So when we got the device, it was locked and secured, and the device had been taken to our high-tech crime unit, and I believe it's still on a gray key attempting to break into the passcode. If you had the passcode, would you be able to examine the cell phone? We would. And the fact that it's on the gray key, do you have any idea how long it'll take to get into the contents of the cell phone? What is a gray key? I've never heard of this term. A gray key. So it's a forensic access tool. Designed for same-day, law-accessible. What does this say? I don't want to buy it. Magnet Gray Key can provide same-day access to the latest iOS and Android devices, often in under 1 hour. So Gray Key is the forensic tool they use to download the people's info off of their mobile phones. Why is it still on Gray Key? I don't know. So he says, I believe it's still on Gray Key, attempting to break into the passcode. That's why they don't have a password. If you had that passcode, would you be able to examine the cell phone? We would. And the fact that it's on Gray Key, do you have any idea how long it'll take to get into the contents of the cell phone? Originally, I was told somewhere around 2 years, but it depends and it's out of our control. 2 years. From the electronic devices that you've collected from Mr. Westerman's house, were you able to determine if Mr. Westerman had an iCloud account or not? We were. And what did you do with that information? So we were able to determine that he did have an iCloud account, and we were able to access that information by a computer that was located in his garage, and we were able to determine Mitch Westerman's iCloud account information. Once you found out that he had an iCloud account, what did you do to gather the information from that account? I sought and was granted a search warrant for iCloud, and we ultimately gave the search warrant to iCloud or to Apple. And did you get back information from Apple? We did. And that information you got back from Apple, tell me what that information was. Just give me a ball. What did you get back from Apple? So from Apple, it was kind of, we have no picking or choosing of what we get, but I obtained, I believe, somewhere around 500 gigabytes worth of data, which Apple provided to us, and it was data which was backed up from Mitch Westerman's devices in some way, shape, or form. And you were able to determine from the information you gathered that the information was on the iCloud, in fact, backed up, so that the information that was on the iCloud was, in fact, backed up from Mr. Westerman's devices. Correct. There are personal photographs and family pictures from the Westerman family, so we believed it was, yes. So, not to be elementary, but to make sure I understand, when you say backed up, meaning that information came from his devices. That's correct. Okay, was the iCloud account registered to Mitch Westerman? It was, yes. I want to back up. Well, strike that. I want to show you what's been marked as State's Exhibit 10. Can you identify that exhibit? Yes, I can. Can you tell me what that exhibit is? So these are screenshots which are located on the iCloud account. These are screenshots of conversations between the individual named Andy, and they were stored within the iCloud. So when you say screenshots, what is a screenshot? Explain that to me. Kind of hard process to explain, but it's a process where you're taking a picture essentially of whatever conversation or whatever's happening on your device. You're taking a picture, a screenshot of that information, a snapshot, sorry. And you have to save it? Correct. And then it's uploaded to an account? Correct. Have you investigated crime? Well, let me back up. Those represent those documents that you found in Mitch Westerman's iCloud account. Is that correct? That is correct. And they represent screenshots of messages found in Mitch Westerman's account. Is that right? Mr. McLeland says, Judge, the state would move to admit what's been marked as State's Exhibit 10 into evidence. It is offered. Any objection? Mr. Hennessy says, preliminary question. The court says, is there any objection? He moved the admission of 10. Mr. Hennessy says, correct, and I asked for a preliminary question. The court says, yes, you may ask. Like, why is she just giving him a hard time for just giving him a hard time? Mr. Hennessy says, are there any dates on any of these pages of the State's Exhibit 10? Not on any of them? To the best of my knowledge, I don't believe there are, no. Say that again, please. I do not believe there are, to the best of my knowledge. Mr. Hennessy says, and then, so do you know when Mr. Westerman allegedly took photos without permission in Mr. Baldwin's office? And I'm going to have to go back to the previous question you just asked because there is at least one date on these. There are also timestamps on some of these, but it depends how the screenshot was taken at the time. My apologies on that. Mr. Hennessy says, I see the timestamps. I don't see any dates on any of these. Well, sir, one of the pages does have a date stamp on it. What? One of the pages does have a date stamp on it. Which one? Since they're not numbered, may I approach the witness? You may. Several of these do have a timestamp, and this one here does have a date and a timestamp. Okay, when you say this one here, it says Monday, September 18th at midnight? Correct. So what year? I do not know. And then you say there's another one with a date stamp? No, sir. I believe there's others with dates, with timestamps. Right. But they do not have date stamps. But so, all right, so Hennessy continues questioning, but so we don't know when any of these were sent back and forth between Mr. Baldwin and Mr. Westerman. The date stamp is not on them. What did you say? The date stamp is not on them. What question did you hear? Can you ask the question again, sir? Oh, this is funny. Okay, so, well, which one did you hear? I said, so we don't know what date any of this exchange between Mr. Baldwin and Mr. Westerman was. I didn't ask what time. Correct. So we don't know what day. And you've admitted that they were discussing discovery, what could be done, should be done on this case. I don't know that I admitted to that. No, you haven't yet? So I guess, how is this a preliminary question, sir? What did you say, ma'am? How is this a preliminary question when you're asking him things you would be asking him on cross-examination? Well, actually, I was trying to establish that it's work product because that's going to be our objection. So the question to him there on the preliminary basis was, does the content, the discussion of strategy, discovery, and matters that are protected by work product? And furthermore, what is it relevant to, since we don't have any idea what year it was done or what date it was done? So what is it relevant to? To show that Mr. Westerman, so your objection is relevance? What did you say? Your objection then is relevance to the admission of this exhibit, work product, and relevance. Yes. Judge McLeland says, Judge, in regards to relevance, I believe it is relevant. I'm just entering it as an exhibit now, but once we get into the contents, the contents show the time frame and when these conversations were held. It's relevant to show that Baldwin was leaking information to Westerman intentionally, purposefully, and that Westerman was not a member of his team, has not signed an NDA to the state's knowledge. They don't discuss strategy. I don't think it's protected by work product. Of course, then he makes that claim. The burden shifts to him to prove that it was work product. I don't think it falls within the exception of work product. It's not attorney-client privilege. It's not anything discussing strategy of the case. It's discussing Baldwin is telling Westerman information that's not out in the public and is telling him about files and documents, and they're going to file before they're filed in the public, and so it's relevant to show an ongoing leak to Westerman. I'll show 10 as admitted over objection. God, she just... Okay. Mr. Hennessy says, Judge, would you seal that so that, 1, it shouldn't come in because Mr. McLeland has no business reading the mental impressions of opposing counsel, and 2, since it does have the mental impressions of defense counsel, it should not be made public, so we ask that it be sealed. Court says, I'll seal it. Mr. McLeland says, I have no objection to that, Judge, and I guess to follow up, I will ask a few more questions of Mr. Rector or Detective Rector, but I am willing to not go into the contents of the messages, just with the understanding would ask the court to please review those messages because I do believe they're important to the contemptuous information, and so if defense counsel's okay with the court reading those instead of me reading them into the record, I'm satisfied with them being sealed. The court says, okay. Question. So he didn't even ask if the defense didn't even say if they were okay with it or not. Well, it wouldn't matter because whether they were or not, she would do whatever she wants. All right, so question. So, Mr. Rector, I want to direct your attention to State's Exhibit 10. I'm going to stand up here so the microphone catches me. There's a gray or a light blue part of the conversation and then a dark blue part of the conversation. Can you explain that to the court, which is outgoing and which is an incoming message? Yes, absolutely. So the blue, back up. Yes, absolutely. So the blue messages would be the outbound messages. The gray in color messages would be the inbound messages that were received to whatever user. And the name of at the top of those messages is whose name that they're from. And the name at the top of those messages is whose name is there, Andy. And again, these are messages that came from Mr. Westerman's iCloud account. That is correct. And these screenshots that you took with your phone, absolutely not. So would these be akin to photos that were saved in Mr. Westerman's iCloud account? Presumably, yes. Photos that were taken from one of Mr. Westerman's devices? Correct. Presumably that he took Mr. Westerman? That's correct. And so you had no part in capturing these photos. You just received the photo from the account and printed them out. Absolutely. This is how they were presented to me, and I did nothing to alter them. You had an opportunity to read through the messages in those screenshots? I did, yes. And do those messages give you an idea of the time frame when the messages were sent? They do. They are specific things that are cited in these messages and that give us a proximity of the timeline in which they would have been sent or received. So while there's no date stamp that states a specific day when they were sent, the messages give you context of when they were sent? Yes. So when you read the content, that would give you some more knowledge to it. I want to go back a little bit later. You also executed a search warrant on a Facebook account of Mr. Fortson. Is that correct? That is correct. And you had an opportunity to examine the messages between Mr. Fortson and Mr. Cohen that you retrieved from individuals, correct? There's ones that would have been retrieved and presented to me by First Sergeant Holman. Okay, so you had an opportunity to go through those messages. I did, yes. The messages we've admitted into evidence today. Yes, that's correct. When you examined Mr. Fortson's Facebook account, were those messages in his account? I did not see them, no. Do you have any explanation of why they weren't there? Objection, relevance, speculation. How is it relevant? I'll withdraw the question, Judge. I don't have any other questions. Mr. Hennessy. All right, so now cross-examination of Detective Ben Rector. Let's start where, towards the end, he kept asking about photos in State's Exhibit 10. I don't see any photos, are there? Well, sir, what he's referring to as a photograph would be the screenshots which appear in photos when you save them that way. Okay, so there's screenshots that came from iCloud. Correct, yes. But there's no photographs in State Exhibit 10 that were being passed back and forth between Westerman and Baldwin. These are screenshot messages, sir. So there's no photographs in the documents between Mr. Westerman and Mr. Baldwin. No, sir. Thank you. So how long did your interview with Andy Baldwin take? I believe it was approximately 2 hours. And was he cooperative? He was. Didn't try to cut you off? He did not, no. Answered every question? He did. Openly and honestly? He answered every question, yes. Did you ask him if he'd ever had any direct contact with Mr. Fortson? I do not believe I asked him that question, no. Did he describe how Mr. Westerman had no authority to take pictures of anything related to the Delphi case? He described that he did not have the authority to take pictures in the conference room, yes. So your answer to my question was yes. Yes. Okay. Did you find out the date that Mr. Westerman confessed to Mr. Baldwin? What we were told was October 9th, when, as my testimony previously was that he showed up at Mr. Baldwin's office on October 9th and told him that he had done it. Sorry, I need a sip of water. All right. And you don't know, and you know that was reported then to the prosecution and the court on October 9th. I believe it was somewhere thereabouts. I'm not exactly privy to all that information. No. And then you interviewed Brandon Woodhouse? I did. And from that, did you learn that Mr. Baldwin, within an hour of having mistakenly sent an email to Mr. Woodson, called Mr. Woodson and told him to delete it? It's Mr. Woodhouse, sir. But yes, Woodhouse. Yeah. Woodson. Who's Woodson? Do you investigate the connection between Mr. Westerman and Mr. Fortson? I know that there was a connection from information received. Sir, just if you could focus on my question, did you investigate any relationship between Westerman and Fortson? That's a yes or no. I would have yes. You would have yes. Do you remember what you did in that regard? I remember some context from photos that put a correlation between the two, but beyond that, I don't know what the relationship was. Were you aware of a leak of the affidavit for probable cause to search Mr. Logan's property that had stamped on it for every page murder sheet? Objection, Judge. Relevance. Same argument I've made to the past judge concerning the hearing today. The court says that's not part of the contempt, sir. The allegations that have been, Mr. Hennessy says, well, it can be if you allow the defense, even though you wouldn't give them time to adequately prepare, you wouldn't extend the deadline. Sir, if you just let him I don't need a talking objection. I'm sorry. I sustained the objection. Thank you. Did she? Because she didn't. Okay. Mr. Hennessy, well, no. I need to respond for the record to the court's she says, I sustained the objection. Thank you. He says, well, no, I need to respond for the record to the court's comment and that it's not part of the contempt proceedings because it is not. It is part of the defense in the contempt proceedings. Thank you. Any further questions? Do you investigate any other leaks? This woman, I swear, Judge Gall, I cannot stand her. The attitude, the way she is with the defense, it's awful. It's awful. Like, she is so rude to this guy. There is no reason to be rude. She's just being rude. I can't stand people who are rude just to be rude. Drives me crazy. All right, so it is a part of the defense in the contempt proceedings. Thank you. Any further questions? Did you investigate any other leaks? I was given information by Brad Rosie at the time of my interview with him about some information that was on a segment by Barbara McDonald. Did you investigate any others? Beyond that, no. And then, so you had access and reviewed the actual email that went to Mr. Woodhouse. Yes, that was provided to me, yes. It was addressed to Brad, correct? That is correct, yes. And Mr. Woodhouse is a Brandon? That's correct. So it clearly wasn't intended for Mr. Brandon Woodhouse. I don't think I can speak for what the intent was. I just know that's how it was addressed. Well, Sergeant Holman does, why can't you? Yeah, well, Sergeant Holman does, why can't you speak to the intent of it? Because I speak to the facts, I don't know. Okay, oh, and you reviewed the thumb drive map that was attached to the misdirected email? Yes, sir. And that didn't identify what discovery is where on on the map, on that thumb drive. I guess you'd have to be more specific. I don't understand the question, sir. That's all right. It's in evidence. Nothing further at this time. Mr. McLeland? No, Judge. No further questions. Thank you. All right. Thank you, officer. You may step down. Thank you. All right. Mr. McLeland says the state has concluded its portion of the evidence. The court says, all right, then this will be an appropriate time for us to break for lunch. If you would report back to the afternoon or courtroom by 1 o'clock, blah, blah, blah. Judge, Mr. Baldwin says, Judge, I had a question. we're not done yet, folks. We're still on the record. Have a seat. Mr. Hennessy, you have a what? Mr. Baldwin says, a question unrelated to this. We had received an order that the motion to dismiss would be heard today. Is that still the case? That was still my intent. Okay, that's all I wanted to know. Thank you. Oh, all right. Be back at 1, please. Now they are off the record, and we're back on the record. Woohoo! The bailiff says, all rise. Court says, thank you. You may be seated. Okay. The bailiff says, no talking in the gallery at all. None. Court says, all right. We are back on the record. Mr. Hennessy, are you ready to proceed? Mr. Hennessy says, yes, Judge. First, I would make a motion pursuant to Trial Rule 41B. At the close of all the state's evidence, I would remind the court that the proof has to establish willful and intentional disobedience. The standard is beyond a reasonable doubt, and that comes from a 1927 case that has never been overruled. And I will quote from that. I just had it. Oh, I'm sorry. Okay. It's the case of State versus Schumacher. The chief parts. Dog. All right. So the chief parts are it's a criminal contempt case. The case is governed by the analogies of criminal procedure, and the respondent is entitled to. The respondent is entitled to the same rules of evidence, the presumption of innocence that avail him in any criminal case. The evidence must be sufficient to establish guilt beyond a reasonable doubt. I want to start with Mr. Rosie because there's truly little, if any, evidence of him at all. The only, if you look at it, he wasn't involved in the Westerman leak. That wasn't his office. The Woodhouse thing, he wasn't involved in. There's no evidence that he was. There's no evidence connecting him to Westerman, and there's no evidence that he lacked any candor towards the tribunal. Now that leaves you with the press conference, and clearly both Mr. Rosie and Mr. Baldwin did the press release, but it's a day before the court order, so that can't be contempt. So I ask for a finding of no contempt of Mr. Rosie at that time. The court says, well, sir, we had state's exhibits 1 through 10 that have been admitted, some without objection, some over objection. I have not reviewed any of those exhibits and am unaware to rule on 41B motion without having reviewed the evidence that has been presented, so I'll have to take your request under advisement. Mr. Hennessy says, okay, then moving on to Mr. Baldwin. The court says, I would have the same response to your argument, sir. I have not reviewed state's exhibits 1 through 10 as it relates to any of the information, and I just want to, if I could finish, please stop interrupting me. You interrupted him, bitch. Holy cow. Whew, okay. Anyways, this woman is disgusting, in my opinion, as a human being. As a woman, as a human being, as someone in our justice system, she's a disgrace. Alright, anyways. Moving on to Mr. Baldwin. She won't let him talk. She says, stop interrupting me. He says, oh, I'm sorry. Somebody said in one of my streams that I was giving the judge too much attitude. I don't care. She sucks. She sucks as a human being, and she's a disgrace to all judges out there. Everything that she's doing is what's wrong with our justice system. Alright, so the court says, I cannot make a ruling on your 41B without having reviewed the evidence, so I will take the evidence and your request as it relates to Mr. Baldwin as well under advisement. Mr. Hennessy says, I just wanted to make my argument so you'd have it when you review the evidence. That's not necessary. I know what your argument would be, sir. Holy hell. What a bitch. You can't possibly know what his argument's going to be because you can't possibly be inside his head, woman. All right, so Mr. Hennessy now calls John Boren to testify. He's sworn in. Now this is direct examination of John Boren. I'm like terrified of Gull right now, but not really. But I mean, I would be if I was a lawyer on the defense side on the Richard Allen case. I would be. All right. Questions by Mr. Hennessy. Please state and spell your name. John D. Boren. He spells it. What do you do? I'm an attorney. And how long have you done that? In October, it will be 47 years. Wow. So you were admitted in October of 1977. That's correct. Where did you go to law school? I went to law school in Oklahoma for the first year. And then I transferred back to Indiana, which was a lot cheaper as a resident. Like, why even have that? Okay. And I went to McKinney back then. It was just Indiana University. Question. What was your practice after admission? Initially, after being admitted, I was a deputy prosecutor for G. Thomas Gray down in Morgan County for approximately 14 months. At the end of the 14 months, January, of 1979, I opened a practice in a little office above Foley and Pedden in downtown Martinsville, and I practiced there for 2 years. And those 2 years, Steve Oliver and I formed a partnership called Boren Oliver. And no, it was not just Boren and Oliver initially. Have you tried both court trials and jury trials? I have. How many approximately jury trials? Approximately 100 jury trials and too many court trials. I couldn't count them. And have you done trial preparation in regard to those trials? I have done trial preparation. Actually, I started trying jury trials when I was an intern. Back then, it was pretty loose, and as my senior year or last year of law school, I tried two jury trials. One was a kidnap, and the other one was a major felony case. So I've been doing jury prep ever since I started, and when I went out into private practice, I paid for myself to go down to National College of Criminal Defense Lawyers, and I met, as I now know, people don't recognize those names, but those were icons at the time. Bobby Lee Cook from Valdosta, Georgia, Racehorse Hayes from Texas, and Garvin Isaacs, who was from Oklahoma, and they taught us a lot of jury prep. And with regard to consulting with other attorneys, is that normal and expected? It is. I obviously still do it today. I think maybe I should tell you that I'm of counsel of the law firm Boren, Oliver, and Coffey now. So I've got one foot out the door trying to clean up all my cases and get out. And how about consulting with non-lawyers? I think it's more important to consult with non-lawyers than with lawyers, although obviously lawyers can give you some tips in regards to the law, but I've only, in 47 years of trying jury trials, I've only had one jury trial in which I had a lawyer on the jury. So it's real important, in my opinion, to consult with non-lawyers. Yeah, non-lawyers are the jury. Non-lawyers, are the jury, not nine. Non-lawyers, you and me, and, well, probably people that aren't obsessed with true crime. But, yeah, it's everybody. It's any citizen in any town, USA. That's your jury. All right, question. And in doing that, so you get a better perspective of what? How your jury will react to the evidence? Absolutely. So in doing that, do you share with them the discovery and what you've learned and what you expect the defense to be? Dogs look struggling to get down the stairs. Sorry. So in doing that, do you share with them the discovery and what you've learned and what you expect the evidence to be? Absolutely. One of the things that I really felt like I had a good handle on was doing what we call mock juries. And for probably about 4 or 5 years, myself and Nina Miller, as a part of the Public Defender Group of Indianapolis, conducted the seminars. And Nina was a psychologist, and we taught prospective litigants how to assemble juries, how to interview jurors afterwards, and the evidence that you want to see what's going to suck the air out of a room or what's going to be benign. Some things that we as lawyers think are real important, mock jurors will tell you they're not important at all. And then the consultation with both lawyers and non-lawyers, is that something criminal defense lawyers refer to as brainstorming? Absolutely. And there's probably another element to brainstorming. Saturday mornings, this is what I'm going to miss when I retire completely, but we would sit around and brainstorm our cases and, talk about the facts and look at the evidence that had been produced. Have you attended continuing legal education seminars where brainstorming was discussed, recommended, and taught? Yes, I have been a presenter at least 3 different occasions in which we roundtabled, and this was for medical malpractice. I did about a 50-50 practice in my 47 years. 50% was civil, 50% was criminal. But one of the seminars that we did was very much a brainstorming, and we would have a group of people who were attending our seminars, and we would do our brainstorming and talk about it. And then are you familiar with the term war room in terms of trial preparation by criminal defense lawyers? Absolutely. Please tell the judge what that is. Well, that's where critiquing your case that you present to, whether it be lay personnel or whether it be attorneys, you get an idea of how your presentation is coming across. And people, hopefully you have good people that will tell you the truth, like this isn't working and this is not, or this is working and this is not. But with regard to trial preparation for a major trial, would you have all the evidence set out in a particular area as you approach trial? Absolutely. In my practice, which is in Martinsville, Indiana, we have 2 conference rooms, and we had a big conference room that frequently we would have pieces of evidence such as photographs, diagrams, and as technology began to increase, we would have, cell phone analysis. All of that would be out in our whichever room we decided to use, and frequently I would have that in my office as well. So, you're not going to be continually picking up and putting away your case file. You need to spread it out and look at things and, come up with strategy and brainstorming ideas. And have you ever sent an accidentally misdirected email? I have both sent accidentally, and I'm not real computer literate, and I've received email that was not intended for me and sent to someone that was not intended. What would you do once you realized you sent it to the wrong person? Once I sent it to the wrong person, I would try to communicate to that person and it wasn't intended for them, or communicate that it wasn't intended for them and that they please delete it. And depending on the magnitude of whatever I sent, I might ask them, don't disclose this to anybody. And if you received a misdirected email, what would you do? When I realized it was misdirected, I would stop immediately, call the person, delete the email, and tell the person that sent it to me that I had deleted it when he received one. Okay. So having taken much corrective actions with either one, would it cross your mind, or would you feel obligated to report that to the prosecutor or the judge? I guess it would depend upon what it was. I would probably, I don't know why I would, report that to either a prosecutor or a judge. So he went back and forth with it in his mind. I guess maybe no. Second thought, no, I wouldn't. That was great. Okay, so you would figure it was cured, right? Correct. Okay. Why are you here? Well, I'm here because I'm getting old and I have experience and I do have training, and you indicated to me that maybe that might be something that the judge would like to know about. Thank you. Nothing further. Ms. McLeland, thank you, Judge. Now, cross of John Boren. And then we still have two witnesses left. All right, so besides John. All right, so questions by Mr. McLeland. Question. Mr. Boren. Good afternoon. Good afternoon. In your vast experience, which I appreciate, have you ever been subject to a gag order put down from a court? I have not been subject to a gag order in my 47 years, and I handled the Stephen Judy case that was before you were born. I'm quite sure. I don't know who that is. Sure. He and I didn't get along well, so I was relieved that I didn't continue that representation, but I have never received a gag order. In civil practice, I received non-disclosure forms that we filled out. Are you familiar with the gag order in this case? Have you read over it? I think I have. My knowledge about this case is probably narrow. I'm sure many people sitting in the gallery know more about this case than I have, but I do believe I've read what that gag order in February of 2022, maybe? No, this was December 2nd of 2022. I think I've read that one as well, yes. If I were to present to you that the gag order prevented parties from disseminating information to the public, that would coincide with your knowledge of gag orders. Is that a fair statement? Right. The gag order can be tailored in whatever way the judge chooses to tailor it. I like that he added that. All right, so question. And if you had a gag order that were in place and you were to consult with a civilian, what precaution would you take to ensure that that civilian doesn't disseminate information to the public? I might make a major mistake and think that my civilian would not disclose anything like that. I think that would probably be my nature. I've never had an onerous gag order. That's probably the best way I can answer your question. Have you been subject to, and I think you've answered this, have you been subject to a protective order in terms of discovery in a case? Protective orders in civil cases, yes, I have. I've never been, let's put it this way, I'm an old man and my memory is not that great, but for over 47 years, I don't remember ever receiving anything like that. And even though Morton County is kind of a small place, but we've had some pretty notorious cases and I've handled most of them. So the protective orders that you've had in civil cases, have you ever violated those? No, I've never I've had one violated and impacted our case, but sure, not me. If you had a protective order and you did violate it, would you feel obligated to notify the court? Certainly, if I realized I had violated it, yeah, I would tell the court. They didn't violate shenanigans. They didn't violate anything. I do call shenanigans going on in Delphi. All right, so question. What precautions, when you have had a protective order for discovery, what precautions do you put in place to ensure that civilian consultants that you have don't disseminate the information that's protected? I've never had the occasion where I had to sit down and tell. Most of my consultants were experts, so were professionals in their field, and I've never had a reason to. Maybe that's negligent on my part, but I've never had to do that. And I bet you a lot of people are seeing this case and going, oh crap, I better start being more careful because I don't want something to be misconstrued by the state coming after me that I'm in contempt. This is ridiculous, especially if you are in Delphi area or Carroll County, where Judge Francis C. Gull sits. All right, so little sip. Everyone take a hydration break. Don't forget to drink water. It's so good for you. All right. Question. When you speak of the war room, would you put any precautions in place to keep the public from entering that war room? Interestingly enough, I consulted with my partner, Mr. Oliver, and like I said, he's been practicing 45 years, and we never put a lock on any door. We never, put a sign up. It's just never was something that crossed my mind. Have you ever, well, if there weren't gag orders and all this protective stuff, people wouldn't feel the need that they needed to leak things. It's so annoying, all these gag orders going on in Idaho 4, in Delphi. It's not right. Cases are not supposed to be in the dark. They're in our courts are public for a reason. All right, interestingly enough, I consulted with my partner. They've never put a lock on. So have you ever been involved in an unaliving case where there were crime scene photos? Oh, yes. And have you ever released those photos to the public? No. In the Stephen Judy case, I remember Tom Gray handing me, here's your copy of these horrific crime scene photos. And I do remember I shared them with a lady next. I was practicing. I was right out of prosecutor's office, and I remember showing them to the lady next door and asking her what her impressions were. Did you ever show those crime scene photos to one of your friends who was not he wants to say not a lawyer. Let me clarify that. Who was not a lawyer. So what? Yes, I'm sure I did. Yes. And they're just saying that to like put a dig at Westerman, because Westerman actually has a law degree. He just isn't a practicing attorney, but he has a law degree, and he is sharp when it comes to legal stuff and legal analysis. So yeah, why wouldn't you want to consult with him? Whether he's a lawyer or not doesn't matter. All right, so okay, and your testimony is that you wouldn't put any safety precautions in place to ensure that those photos didn't get disseminated to the public if you were to show them to a non-lawyer consultant. Well, now you are assuming that there's an order telling me that I have to do that, or I've got to take precautions. Sure, let's assume that. Let's assume you're bound by a protective order. Is there anything you would put in place to protect those pictures from being leaked or disseminated in the public? Hennessy says, objection, Judge. Mr. Boren, asked for clarification if there was an order to secure his war room. So then McLeland switched that around to whether there's a protective order, so it's an assumption. It's not the question whether the court ordered the war rooms be secure is an assumption that's not in the case because there was no such order. Sustained. Holy crap, she's sustained. I think that's win number 5 for us out of these whole proceedings. Everything else is gone Nick's way, but all of the rulings except for now, I believe 5. Maybe we're on 6. If anybody is keeping track in the comments below, let me know. I think we're on 5. That we've gotten sustains on our objections. Everything else is overruled. All right, so have you ever lied to the court? Have I? Yes. Certainly not knowingly. I've never lied. Sure, because the definition of a lie is that you, lie. You have a professional liability as an officer of the court to be honest with the court. Is that a fair statement? I have a real aversion to the disciplinary commission. I agree. Have you ever told the court one thing and then done the complete opposite? When did anybody do that? All right, he's alleging something that I don't even know what he's alleging. I certainly don't recall ever doing that. Okay, I would say that I'm certainly capable of forgetting things, and my staff tells me, sure. I'm even worse now than before. Sure, understand. Thank you, Mr. Boren. He wasn't getting what he wanted from Mr. Boren, so he's like, all right, forget it. I quit. I bail. I have no more questions. Mr. Hennessy, no redirect. Thank you. All right, thank you, sir. You may step down. May he be excused. The court says, Mr. McLeland says, Yes, from the state's perspective, Judge, I don't intend to recall him. Mr. Hennessy. Okay, thank you, Mr. Boren. You may call your next witness. I call K. Beehler, sorry. Witness is sworn in. Direct examination of K. Beehler being asked questions by Mr. Hennessy. And I'm gonna this one and one more. So I assume these are a bit shorter. All right, so questions by Hennessy. Please state your name and spell it. K. Beehler, and she spells it. Okay, what do you do? I'm a lawyer. What kind of area of the law? I'm a criminal defense lawyer. And this is really important because a lot of judges don't necessarily have defense attorney backgrounds. Not most, but a lot of judges out there, You're supposed to be completely unbiased. You're supposed to be very, very neutral. But everybody has biases that they come with on their own. So if you have been a prosecutor for the last 20 plus years and finally you become a judge, you are going to think prosecution wise in every case. Like, that's just the way you filter things because that's your experience and your knowledge and your bias. It's implicit. I mean, it's just within you. You can't do anything about it. So, I mean, we all have our own different biases. If you're a defense attorney and you come into being a seated judge, you're going to think more towards the defense side. It's just, that's the way it is. So it's very, very, very important that he has these witnesses testifying to what defense attorneys do as normal, regular, everyday practices when they are prepping for trial and what they do. This is so important because a judge who has spent her entire time as a lawyer being a prosecutor and trying to get the bad guy, that's how she thinks. And in her mind, Richard Allen is the bad guy. She's made that abundantly clear with all of her rulings. And don't even try to tell me that she's neutral. Don't even, or whatever. I don't know. You can come for me in the comments, tell me that she's neutral. And I'll tell you many examples of how she isn't. Anyways. All right. So continuing on. What kind of area of law? I'm a criminal defense lawyer. Did you start in Indianapolis? I did. You start as a prosecutor? I did. Did you do, for about 3 years, did you do criminal defense work in Indianapolis? I did. And then where did you go? I was in Indianapolis with the Public Defender Agency until 2004, and in March of 2004, I made my way to the state of Maryland and worked in their Capital Defense Division doing DP defense only. And have you retired from that position? I've tried, yes. I'm not very good at it. So she's not retiring. She's still doing consultant work probably. Or she's still busy doing some things. I don't know. Are you back in Indianapolis? I am back in Indiana. I'm in Vigo County right now. I specialize in appeals. So you've had both court trials and jury trials. Yes. And you've done trial preparation for court trials, for both court trials and jury trials. Yes. Please provide your trial preparation to the court. I have interviewed witnesses, I have gone to the scene, I have looked at, examined, and photographed every piece of physical evidence in a case. We've made whiteboards, files, particularly in capital cases. We would have a room, an absolute conference room full of file tubs. In capital cases, it was discovery. I've brainstormed with other lawyers. I have developed a theme of my case and tried to prepare my presentation around that theme. Have you brainstormed with non-lawyers? Oh, yes, absolutely. In doing both, Would you reveal the evidence so you could get their true reactions to it that you might find at a trial? Of course. Have you attended continuing legal education seminars where brainstorming was discussed and taught? Absolutely, yes. Many, many sessions on brainstorming, and particularly sessions on how to get your point across, how to put your case in front of a jury. And would you share sensitive or graphic evidence with non-lawyers to ascertain their reaction? On occasion. It would be case specific. It would be case specific, but yes, it absolutely happens. Have you ever accidentally misdirected an email? Oh, yes. How many times? Oh, once or twice. Have you ever received a misdirected email? I have. And what would you do when one was sent to you? When I sent one, when you sent one, sorry. When I sent one, depending on onto whom and what the subject was, I would normally either pick up the phone or send a quick email back and say, disregard, irrelevant, not for you. Or I'd pick up the phone and say, just delete that, please. But did I ask what you do when you received one? When I received it, knowing it wasn't for me, I just scrolled on by, I just deleted it, wrong guy, wrong person. So once you've taken curative action, like deleting or calling the person, would you see any need to report it to a prosecutor? No. Or a judge? No. Do you know Mr. Baldwin or Mr. Rosie? I do not, only from the publicity surrounding this case. Thank you, Mr. McLeland. Thank you, Judge. And now we are on to cross-examination of Attorney K. Beehler. Mr. McLeland is asking the questions. Ms. Beehler, have you ever been subject to what we refer to as a gag order in a case? Yes, I've gotten them before. I've asked for them. Okay, and have you ever been subject to a protective order for discovery? Yes, I'm sure one right now in federal court. Or I'm under one right now in federal court. With a gag order specifically, if you violated the gag order, even inadvertently, would that be something you'd notify the court of? I'm not sure specifically. If you disseminated information in violation of the gag order, even if it was an accident, would you notify the court that you had done so? Probably at the next opportunity, depending on what it was. I would note disseminated evidence or at least witness list or witness names and discovery in a case. What would you notify, or would you notify the court if it was a violation of a gag order? No, she says. Okay. And you said you were subject to a protective order. When you would show or converse with non-lawyers, would there be anything you put in the place to protect the evidence so that you would comply with the protection order? There is a mechanism to brainstorm a case and not violate a gag order. It's done all the time. Bam! In your face, Nick McLeland. It's done all the time. Sure. Have you ever released crime scene photos to the public? No. Have you ever lied to the court? Have you ever what? Have you ever lied to the court? No. What a scumbag to ask her that. I don't have any other questions, Judge. Yeah, and she schooled you, and so did the guy before her. All right, so no redirect. All right, thank you, ma'am. You may step down. All right, Mr. Hennessy now calls Andrew Maternowski. Witness is sworn in, and now direct examination of Andrew Maternowski by Hennessy. Please state and spell your name. My first name is Andrew, middle initial C, as in Charles. Last name is Maternowski. And he spells it. He was really specific there. All right. And you're a criminal defense lawyer? Yes, I am. How long? I'm in my 35th year. And where did you go to law school? I went to IU Indy. And what was your practice what was your practice after? When did you get that admitted? 1989, fall of 89. And that was your practice after that? When I was in law school, I did a certified legal externship, I guess, is what you'd call it, with the Marion County Public Defender Agency. At that time, during my summer job, I was also working for a private attorney in Indianapolis doing criminal defense. When I finished school, I think the day I got sworn in, I did a hearing that afternoon in Marion County and have spent 17 years working with that attorney, doing almost nothing but criminal defense. Then I moved out of the building into another building for 10 years doing almost nothing but criminal defense. And then I moved back to the original building 6 or 7 years ago. So it's always been primarily criminal defense. Approximately how many court trials and jury trials have you had? Court trials, I have no idea. Jury trials, 35 to 50. I've never kept track of numbers like that or caseload or anything like that. How many different jurisdictions? I've practiced throughout the state of Indiana. We have 92 counties. I think I've counted up. I've practiced in over 80 of them. Probably juries in 15 to 20, maybe 25 different counties. I've done stuff in federal court in the Northern District of Indiana, the Southern District of Indiana. I think it's the Eastern District of Tennessee, a jury trial, and then a jury trial in Missouri, and a jury trial in, not a jury trial, a criminal case in San Antonio, Texas, in federal court. And in your trial preparation, would you consult with both attorneys and non-attorneys? Yes. And would you share with them the expected evidence? I would. For those trials, I would. And why do you do that? To get a better perspective. I've found that when I'm preparing for a trial, because I'm looking at my client's best perspective on how are we going to try this case and win this case, the term I've used is breathing your own fumes. When you think you have a great theory of the case, theme, a great approach to how you're going to defend the case, and then you call your older sisters and they tell you, I can't use the term my sister used, but that you're on the wrong track. That's funny. Yeah, you like the friends and family, your close people in your life, if you're talking to them about your cases and trying to get some perspective, like there's nothing wrong with that. And they're the ones that are going to give you the most honest and helpful information. All right, so you've heard me discuss with the other attorneys about a war room? Yes, sir. What's your definition of a war room? Essentially, a conference room where everything is spread out. A lot of younger attorneys today can do everything on their phone or an iPad or a tablet or a laptop. I can't. I have to have printed pieces of paper spread out everywhere. When I start preparing my case, I make copies of almost everything, and then I make a copy with color-coded pens where I do all of my notes, and I need a copy of that to be able to pick up and look and hold, and then pick another piece up and look and hold and say, okay, here's what witness A said, here's what witness B said. I can't do that on a computer, so what I do is we have a conference room on the 3rd floor and a conference room on the 1st floor. I'm in an old house on the north side of Indianapolis, and there's a big table on the 3rd floor, and there's a big table on the 1st floor, and I would spread things out all over those tables, depending on which one I started using first. Have you received a misdirected email? I have. I've received many over the course of time, one from a prosecutor when he and I were discussing the deposition, and when I received it, I sent it back to the prosecutor and said, this was not for me. Question. Was it apparent from the email that he was intending to send that to a police officer? Yes, we were in the middle of talking about a suppression issue and trying to schedule a deposition. And the email that was sent to the police officer, or intended to go to the police officer, was actually went to me. indicated that, referring to me, that I apparently figured it out what the suppression issue was, and I told the prosecutor that I received the email, and within a couple of days, I think the case was dismissed. And have you attended CLEs where brainstorming was addressed or taught? Again, that's like continuing education, legal education. And have you attended CLEs where brainstorming was addressed and taught? I've both attended and taught at seminars. Tell us a little bit about your teaching. Okay, for 22 years, I've been on the faculty of the Trial Practice Institute. It's an annual program put on by the State Public Defender Council where we break down cases into small groups, and you start with brainstorming, and you start with then move into voir dire techniques and direct exams. I'm sorry, I'm like getting myself all confused here in the text. Brainstorming, and you start with, then move into voir dire and direct exam, cross-examine, opening statement, closing, and you essentially, when you're in the brainstorming part of the case, we used to work from a set fact pattern. There's a fact case out there. There's a fake case out there. What is wrong with me? Like, I get to a point where my brain just stops working. It functions no more. Let me keep going. Let me back up on that sentence. Or the whole paragraph. All right, so for 22 years, I've been on the faculty. Oh my God, stop putting the wrong words in there, Heather. You suck. For 22 years, I've been on the faculty of the Trial Practice Institute. It's an annual program put on by the State Public Defender Council where we break down cases into small groups, and you start with brainstorming, and you then move into voir dire techniques and direct exam, cross-exam, opening statement, closing, and you essentially, when you're in the brainstorming part of the case, we used to work from a set fact pattern. There's a fake case out there where there's some allegations against the person at two different crime scenes, and everybody worked from the same fact pattern. About 15 years ago, we shifted to a bring your own case format where every participant, these are public defenders and private defense attorneys from throughout the state, would bring their discovery and bring their cases with them. We found it more helpful to do real facts and real cases that people were really going to be trying in the future. And you've described your war room as being separate from your practice office? Yes. And would you expect to be betrayed by a friend or former associate that comes to visit you in your private office, but unknown to you goes into your war room and takes pictures of the stuff in it? I would not. Would you feel any need to put up protections against such a thing? No. You would not anticipate such a thing happening. Oh, the location where the war room would be set up and everything would be spread out would not be in a location where I would expect anybody. Well, from the general public, but what if they were a friend or a former associate and had come to where your office is and found you unavailable? Would they be passing like the first floor war room? In order to get to where my offices or separate offices, they would go alongside where the war room is. So they could go in there and take pictures without your knowledge. Yes, and you would not expect you would suffer such a betrayal. I would not. That's all I have. Mr. McLeland, cross-examination of Andrew Maternowski by Mr. McLeland. Mr., can you... He just calls him Mr. I think he forgot his name or didn't know how to pronounce it. Can you say your last name for me one more time? I apologize. That's right. Maternowski. Okay. It's a lot simpler than people try to make it. Thank you, sir. Good afternoon. Good afternoon. I want to talk about some emails first. Well, let's back up. Have you ever been subject to a gag order? I have. In a case? And have you ever been subject to a protective order? Yes. And you had talked about if you inadvertently sent an email to somebody, if you'd inadvertently sent an email to a civilian in violation of a gag order, would that? Mr. Hennessy says, Judge, I'm going to object. I don't think he's going to eject out of his pants or something. I'm going to eject. Assumes facts not in evidence. A misdirected email was not violation of the gag order. That's a legal conclusion for this court to make. Now, if he wants to say, ask the question, did you ever send an accidentally misdirected email that had an outline of your discovery organization, that would fit the evidence so far. The court says, would you like to finish your question before I rule on his objection? Sure. What a bitch. Judge, I'd like to respond to the objection too, but let me see if I can rephrase it in the same way. If you sent an email to a civilian in violation of a gag order, is that something that you would feel that you need to make the court aware of? It would depend on who... So did she even rule? No, she just lets him answer. It would depend on who that civilian was. If I just sent it to somebody random, yeah, I probably have 5,000 people in my contact list. If I misclicked on something and it went to somebody, I would probably notify them immediately and say, that wasn't for you, don't do anything with it. Because I don't know what they did with it. I don't know that I'd have a reason to notify the court. I didn't intentionally violate it. Okay, so let me make sure I got this correct. So if you sent an email that violated a gag order that was in place in your case, meaning that email would have to have some information pertaining to the case or evidence pertaining to the case, you wouldn't feel it necessary to notify the court that even inadvertently, if it was inadvertently, that you had done that. Wow, he's insinuating it was all intentional. I wouldn't notify the court at first. I'd probably notify, in a typical case for me, it would be the prosecutor. I would say to the prosecutor, hey, this is what happened. What do you want to do? Okay, fair enough. So finally somebody answered this question the way Nick wanted them to answer. So what's he going to do for follow-up? If they said, we need to tell the judge, we'd tell the judge. Fair enough. Oh, wait. I wouldn't notify. Okay, fair enough. And he continued his answer. If we needed to tell the judge, if he said we need to tell the judge, we'd tell the judge. Fair enough. You had talked about oftentimes, maybe not oftentimes, there's been times that you've had cases and you've run the information by your sisters or sister to get their take on the presentation of your case. Yes. Okay, go ahead. I've got a D felony for a level 6 jury of older sisters. I've got 7 older sisters, and they're all semi-professionals, and they've got a lot of experience. I've got one sister who's a retired nurse, one who I trust her opinion on medical things more than any doctors, and I've had more than any doctors that I've had look at autopsy photos, injuries, things like that. Oh, wow. That's a pretty neat tool to have at his disposal, if being in what he's doing. And is that what you do? And is that for you to be able to get someone from the public, their opinion on the strength or weaknesses of your case? With that particular sister, no, that's usually for more of an expert opinion, but I've done similar things with other people, other civilians, other family members, other attorneys, friends. And again, is that to determine the strength and weaknesses of your case as you see it? Yes. Okay. And so is it fair to say that with the evolution of the internet and the evolution of social media, that an attorney could also use social media and the internet as a way to push out the facts of their case to gauge the public response? You could, yes. Okay. I'm not sure how useful that would be if you're not getting any feedback. I don't have any question, Judge. Thank you. No redirect. Thank you. All right. Thank you. May he be excused. Thank you, sir. You may step down. And can Ms. Beehler be excused? I have no objection, Judge. Yeah, that's fine. The court says, yeah, that's fine. You may call your next witness. And with that... Oh, wait. There's a... Let's read this affidavit real quick. Or go through this before we get... before I end it for part 4. I missed this part when I was going over it. Some affidavit. All right, so Hennessy says, Judge, at this time, I would like to have an affidavit of Thomas Leatherman marked as Exhibit D. You have all these, right? McLeland says, yes. Are you going to attempt to admit all the affidavits that you gave me? Yeah. Judge, Mr. McLeland says, okay, Judge, I just want to show the running objection to those without the witnesses here to testify. I don't think it's fair to the state. We don't have an opportunity to cross-examine them or question them about the information in the affidavit. And so, if the court would just show my objection to the exhibits being submitted to the court. I'll show a continuing objection. I'm sorry. What was D? Mr. Hennessy says, D was Thomas Leatherman. C is Stacy Uliana, or Juliana, I don't know. And F is Amy Schultz. G is David Pumphrey. H is James Fry. So there's an affidavit from James Fry in there. I is Lisa Johnson. J is for Joel Weinecke. And K is for... I don't even know how to say that. K is for some other person. All right. He's Lake County. And then he spells it. And I would call, the court says, okay, excuse me, so you are moving the admission of D through K. Defendant's exhibits D through K offered. Yes, ma'am. And the state is objecting. And your grounds again, sir. Judge, the state's objection is based on the fact that these affidavits, the state doesn't have an opportunity to cross-examine these witnesses in order to check the veracity of the statements made in the affidavit and to question them about those statements. Any response to the objection? No, ma'am. Then I will show D through K not admitted because the flappin' Nick McLeland objected, so she bends over, kisses his butt, and says, okay, I won't admit these. When everything else, the defense has objected over, and she's admitted them anyways. Tell me that she's not biased. Just look at this. We have had 5 wins over this entire, so far, proceedings, and we're going on, each of these have been like an hour and a half. So, yeah. This was the better half of the day that they talked all day. So, I mean, they already went to lunch, so we know that they're back from lunch. I cannot understand this judge. She makes me so angry. Like, just the fact that she is so blatantly biased and doesn't even care. That makes me so mad. I think I'm going to have to write her a letter or something because I can't hold it in anymore. Anyways, you guys let me know in the comments below what you think about this case. What do you think is going to happen in part 4? I have no idea. Part 4, I will tell you, we have Mullen coming back, and also Jerry Holman's coming back. We've got 2 individuals, Julie Melvin and Stephen Wood. I'm not sure who they are, but that'll be interesting to find out. And we also will have Bradley Rosie, one of the defense attorneys, on the stand in part 4. So you don't want to miss that. Please make sure the notification bell is on so that when part 4, when I put that out, you guys won't miss it. And be sure to check out my other videos on the Frank's hearing and all of that. So I thank you so much for watching, and I hope you take care, and I will see you in the next one. Bye now. If you've been impacted by a true crime and would like